articles in piece of land, and who has the right to claim possession of that valuable article. Now, so another new concept about ownership of land. This proprietary rights to possession not only give you the right to possess the airspace, but also extends to all property fixed or placed on the land, because this is part of the definition. And the general principle is that this owner, who has the proprietary right, also has the best claim for any valuable items found on the land where the true owners cannot be found. So if someone left a valuable item on your garden or in your living room, for example, now of course you know who is the owner, you will call him or her and ask him or her to get it back. But if no one say, oh, I did not, no one say he left that article, then if you are the owner, you will have the best claim. So in this case, B may have to give the gold ring to A, who is the owner of the land. Of course, if A is generous enough, he can give it to B. But as a matter of principle, then A would have the right over and above B. Now, there are exceptions. The case Parker and British Airways Board. Now, what happened in this case is that someone left a valuable item in the lounge operated by British Airways Board. And Mr. Parker, one of the passengers, discovered this valuable item. Later on, no one come to claim that item, and Parker wants to get it. And British Airways Board said, oh, thank you very much for finding this one for us, but I'm the owner, or at least is the tenant of that lounge, so I would have the best claim. But in that case, the court ultimately said that Mr. Parker is entitled to the article. Why? Does it mean that British Airways Board does not have the right? No. The court said the landowner must show a sufficient intention to possess those valuable items in order to claim ownership on the articles found on this land. But in that case, British Airways Board set up a loss and fine department. What does it mean? It means he has no intention to possess any loose item. Therefore, Mr. Parker, who discovered the item and no one came to claim, he has the right over and above British Airways. If there is no loss and fine department in the lounge, well, of course, British Airways would have the right because they are the owner of that piece of land. And in this case, Mr. Parker is one of what we call a licensee. Now, trespasser is one who has no permission but enters another person's land. Licensee is someone who has the permission but he has no proprietary rights. License here actually means a permission to enter the land. We'll come back to this concept later. Now, if you are talking about the right to claim ownership on articles left on the land, the trespasser never have any rights. Mr. Parker has a right because he's a licensee. He has this right to enter the land. That is illustrated in this Thatcher's case. Now, what happened in this case is that now we are talking about a local government, Waverley Borough Council. This council had a public park. Everyone can enter the park. This Mr. Thatcher get a metal detector, enter the park, and search for valuable item. This guy is lucky. He find a gold ring, and he wants to claim that item. Waverley Borough Council said no, too bad. We want to keep this. That we have a precedent here. Parks have to share with you. In your park, you also have a loss and fine. So I certainly would get the article at the end of the day. But in that case, it was the local government who finally get the valuable item. Why? Because Thatcher does not enter the park as a licensee, but as a trespasser. Now this is very interesting concept. Now you would say a park is open to the public, so everyone would have an implied license to enter the park, right? Just like a supermarket, you can just enter the parking shop downstairs, even though you have no intention to purchase anything. You just want to enjoy the air conditioning. It's all right. You got the license to enter. Why Mr. Thatcher in this case does not have the license? This is because he entered and has an intention to find valuable items in the park, and that is over and above or exceeding the license given to any visitor of the park. Now, make it easier for you to understand. Imagine you go to the parking shop downstairs. You tell the shop manager, I want to enter. He said, okay, welcome, by all means. But if you say, I want to enter and steal something, would he or she allows you to do that? Of course not. Because the license, the implied license, open to the public would be allows you to go inside the shop, get the food or whatever item you want to purchase, or even look around. It's okay. But definitely they would not give you the permission to go inside in order to steal, right? So, well, when you study criminal law, in fact, this is a very interesting concept about burglary. When you go to that concept, you will find what I just said very useful. Here, Mr. Thatcher, the local government's argument is that, yes, we give an implied license to anyone to come in the park to enjoy fresh air, enjoy the scenery, enjoy the trees or animals inside. But we never allow someone to come in and find or look for valuable items. So Mr. Thatcher entered as a trespasser, and a landowner always has superior rights over a trespasser in claiming ownership of articles found on his land. So even though the landowner, in this case the local government, may not have the intention to possess, nevertheless, his right to claim is always over and above any trespasser who has no permission to enter the land. Now, so if we go back to the first line or the second slide, I don't want to go back because there were 37 already. What do you mean? What do I mean when I say I own a piece of land? Now you can tell me what actually I own. Not just that physical piece of land, but anything attached to the land, including if there's a house erected on the land, I own that house. Also, if there are any flowers, any trees, any whatever, rock, whatever, attached to the land, I own them. Because by definition, they are part of the land. Not just that. I have the right, I have the right to possess the airspace above my piece of land up to a reasonable height for my reasonable enjoyment. And I have the right to anything found on that land where the owners cannot be located. So that is the meaning of I own a piece of land in Taipo or Yunnan. Not just that piece of land, I have all these rights. This is the concept of ownership of a piece of land. So when you say, proudly say to your mother, Mom, I purchased a piece of land in Taipo. And maybe she said, oh, what's so great about it? Oh, because I not just own this physical piece of land, I own many things. You know, all the grasses, all the things attached to the land, any house erected, any structure erected there, all belong to me. Yes, I also own the airspace. Everything. So that is the concept of proprietary rights to possession. That is the concept of ownership of a piece of land. Now we are talking about piece of land, not just flat, not flat. Flat is a completely different story. Okay, we'll come to that concept a little bit in the later lectures. Now, because things attached to land becomes part of the land, it is really important to distinguish some two categories of things that we brought to the land, called fittings and fixture. Now, you rent a place, you move in with your furniture. Now, most of your furniture are fittings. They are not attached to that flat. They remain to be show in possession, belong to you. Okay? But don't fix anything on that piece of land, because that would become fixture, and they fixture are part of the land unless you get the permission of the landlord to remove those fixtures. Either you will commit the offense of theft by removing them, even though to begin with you are the purchaser of those articles. So pursuant to Section 2 of CPO, Commencing Property Ordinance, things attached to the land may become part of the land. They are called fixture. And are the movable things. They are movable. They are not attached to the land. They remain to be chattels and are called fittings. And therefore, it is sometimes important to distinguish what are fittings and what are fixture. Because in a sale and purchase of a premises, you are supposed to sell the entire premises. That would include all the fixtures. You cannot say, oh, I sell my flats to you and then I demolish everything, you know. Say, oh, this is the flat. No, you cannot do that. You cannot remove anything fixed to that flat. And it is not always easy to draw a line between fixture and fitting. And traditionally, there are two tests applied by the court to distinguish what are fittings and what are fixture. And these two tests, number one, degree of annexation, how the article is annexed or attached to the land. The other, purpose of annexation. Why this particular article is brought to the land and attached there. For degree of annexation, the question to ask is whether the article is fixed or movable. Very simple question. If it is fixed, then no matter how slightly it is actually attached to the land, it is generally a fixture. Okay, generally. Now, I don't know whether you know what is a Japanese stone garden. You know, many of my students in the past love Japanese culture very much. Many of them know. Now, in Japan, if they have a garden, sometimes they just put some stone in a particular shape, and usually they meditate, before those stones, sitting on some stone. But the stone remain movable. So I'm asking you this question. Are the pieces of stone placed in the Japanese stone garden fixture or fitting? There's no attachment. It's just placed there on their own weight. Now, the leading case, Holland and Hudson, Justice Blackburn said that if an article in question is no further attached to the land than by its own weight, it is generally considered to be a chattel. Again, generally, not always. And comes to more important case, more relevant case, in which the court was asked to decide whether some stone sits resting on its own weight without any other forms of attachment to a fixture and fittings. So applying the early case, they should be classified as fittings. But in this particular case, the court held that they were fixtures, even though there was no attachment whatsoever, because the stone sits form part of the architecture design of the house, so that they become part of the house. Now, so generally, the test of degree of annexation is this. If it is slightly, even if it is slightly attached, as long as there's any attachment, then generally it should be classified as fixture. If the article remains on the land on its own weight without any attachment, then generally it is a fitting. But the more important test is the purpose of annexation. And in this test, the focal question is the reason why the article was brought to the land. And in fact, Justice Blackburn in the early case has already anticipated that. So he said, perhaps the true rule is that articles not otherwise attached to the land than by their own weight are not considered as part of the land unless the circumstances are such as to show that they were intended to be part of the land. So attachment is one thing to consider, but the more important thing is to consider why the article was first brought to the land. Are they intended to be part of the land, even though it is not really attached? And that, on the contrary, an article which is affixed or attached to the land, even slightly, is to be considered as part of the land unless the circumstances are such as to show that it was intended all along to continue as a chattel. Now you will have a defense when you remove your nice television set mounted on the wall. You can argue, well, I'm not stealing that television set, even though I mount it on the wall, because all along this television set was intended to be my TV, but not part of the land. If you can persuade the court, then you can take it away. Of course, that would be troublesome. The best thing is to insert a term in your tenancy agreement that you can ask for permission to attach things on the land from your landlord. And of course, a reasonable landlord would not say, oh, you put the television set on the wall, so I will take your television set. Normal, reasonable landlord would never do that. So, the purpose of annexation is a more important test. And because the purpose of annexation is actually the key, then similar objects may be found to be fixture or fitting as the circumstances may be. And this is a recurring exam question. Air conditioning system. Now, in most air conditioning system, they would be attached to the land in one way or another. Now, but we have 3 cases cited here. In 2 of the cases, the air conditioning system were considered to be fixture, and in the other, they're considered to be fitting. So it all depends on why they were brought to the land and how they were actually attached to the land. So frequently in the exam, there was a question asking you in 2 parts. Part A, why it is important to distinguish fixture and fittings. And then second part, are air conditioning system fixture or fitting? So in the first part question, you should answer, oh, there are 2 tests, or 3, in fact 3 tests. In due course, we are looking at the 3rd test. There are this test, and depends on the purpose of bringing the things inside. And the importance is that under the definition of land in Cap 2179, things attached to the land or permanently fastened to things attached to the land are part of the land. And then, the air conditioning system would depend on the purpose and how they were attached. Therefore, in these 2 cases, they were considered to be part of the land or fixture, and in the other case, it is not considered to be fixture and fitting. Now, this is one example of how to distinguish whether an air conditioner should be considered as fixture or fitting. Well, nowadays, this is not that common. When I was young, it is more easy for a government civil servant to have a staff quarter. But now it seems that it is only really high official would have this right. Now, one interesting thing about government quarter is that the government would not provide you with air conditioner. So you have to install the air conditioner yourself. Now, here we have Mr. A assigned to move in a government staff quarter, and he intends to install a new air conditioner in the quarter, but because he has been my student, he learned about fixture and fitting, and is afraid that the air conditioner will become fixture of the quarter when he moves out. The question asks you to advise him. And the question can be easily answered in this case. Government never consider air conditioners as part of the land. Therefore, when the staff move in and install an air conditioner, they would remain as chattels or fitting, but not fixture. Now, there is a third test for fixture, which is actually a further development of the second test, purpose of bringing the of annexation. The question is whether the articles in question has become part and parcel of the land. Now, this is a very interesting case, Go-Full-Way Development Limited. That happened in, look at the year, 1999. And if you are old enough, you should remember in 1997, when Hong Kong was going to become Hong Kong SAR, there was a very, how should I describe it? A strong sense of optimism. Everybody think or thought that, well, tomorrow will be better. So the property market in those days jumped sky high. And actually, just about 2 years ago, the prices for real estate, broke that record in 1997. But unfortunately, November 1997, few months after Hong Kong became Hong Kong SAR, there was an Asian financial storm, not as serious as tsunami, but serious enough to make the price of real property in Hong Kong drop drastically, at least 30 to 50%. So in those days, later on we'll learn the sale and purchase of real property in Hong Kong usually at least lasts for a month. So many purchasers, when they enter into the contract of sale and purchase, agreed to purchase in very high price, thinking that, well, the price would still go up. But suddenly, when this storm came, the price dropped 30 to 50%, and it was before the sale and purchase complete. So all purchasers in those days want to avoid the contract. Now, you have already learned the contract law. You should know that if you want to terminate the contract, you have to show that the other party is in breach of a condition or serious breach of intermediate term. Remember this? So they are trying to think of ways to get away from the contract. And put it short, one very simple thing to make the contract not enforceable against the purchaser is to say there is illegal structure on the premises. Now we will come back to this, why it is a factor to get off from this sale and purchase agreement later on. But at this stage, let's just take it this way. As long as you have illegal structure on the premises, then we say the title of that property was a bad title, and the purchaser would be able to get away. Now, what happened in this case is there is a standalone house in Stanley. Okay? And the owner has built a glass extension something like a tunnel that you can go to the garden. The purchaser is very happy because he said, obviously, because in Hong Kong, I can bet no one would actually apply for permission to make additions to a standalone house. So without the approval of the buildings authority, it's an illegal structure. Illegal structure, therefore, they can back off. But the drama is the owner dismantled the glass structure. The illegal structure gone. So you have to purchase. You have to complete the sale and purchase. So the question for the court is that whether this glass structure is fixture or fitting. If it is fitting, of course, you can remove the fitting. But if it is part of the land fixture, then when you remove that part, you are no longer selling me the same piece of land when I execute this sale and purchase agreement with you. And you are definitely in breach of the contract. I order for 10 orange, you only give me 8. Remember the case, same number of orange but different packing would allow the party to, rescind the agreement. So the court was invited to decide whether this glass structure should be classified as fixture and fitting. And in that case, it was Maria Yun, Justice Maria Yun, as she then was. She's now a Justice of Appeal in the Court of Appeal. But at that time, she was only a High Court judge. She said that because we have no evidence about the purpose of bringing this or erecting this glass structure, so she has to develop a third test to decide whether the glass structure should be classified as fixture and fitting. Instead, the question she asked was whether the article, that is the glass structure, has become part and parcel of the land. And the court consider the degree objective purpose of its annexation, come to the view that this glass structure, the greenhouse, was part and parcel of the land, and it was a fixture and part of the house to be sold. So when the vendor removed that glass house, that greenhouse, then it was a breach of contract, except performance, right? And well, I have more explanation in the slide, but I'm not going to read out all these. Later on, we'll come back to this section, section 16 of CPO. In this section, it is provided that all the fixture fittings would also be transferred from the vendor to the purchaser. And now, since this fixture has been removed, the vendor of the land was in breach of contract, and the lucky purchaser get off from the court. So these tests about fixture and fittings are really important, Okay, we'll come to another new set of concepts called estates and interest in land. As I said, the word estate has many, many different meanings. And in this context, estate may refer to the duration of holding of the land. This is really, in England, we'll ask you, what is your proprietary right to possession? How long you can possess? So this is the holding of the land, and we use the word tenure, the tenure of the right. And therefore, in fact, why we call the person who rents the land tenant, because they are actually holders of the land, hold the land for a definite period of time. And estate refer to the duration of holding, how long. And there are two main types of estate, two main duration of holding: freehold and leasehold. Freehold means you can hold the land forever. There is no definite end to that duration. Now, in Hong Kong, we don't have, we only have one particular piece of land that is on freehold. But in England, there are many land in which the estate of that land is a duration, indefinite duration. That is to say, in theory, the owner of the land can hold this property forever until the earth, has destroyed or whatever. Leasehold is for a fixed duration. Therefore, we say lease or tenancy. That is for a definite duration. And just to give you another meaning, estate in land law has another meaning. We refer to the proprietary rights to use and control the land. Therefore, if we have this term estate in land, it also means the ownership of a land for a duration of time. And from time to time, we see the term legal estate. You can interpret this term as legal ownership or legal proprietary right. Now, interest and estate basically have the same meaning, but not about duration. This is about the ownership, the concept of ownership. But interest is usually used to refer to proprietary rights existing in equity. Now, if you still remember your legal system, we have two different legal traditions running parallel in common law in England. Common law tradition, equity tradition. So we are talking about two different legal rights. And we usually use the word interest to refer to equitable rights. So the correct way to describe the interest in land, if it comes from common law, we call it legal estate. If it comes from equity, we call it equitable interest. Now, you can use the word interest to describe a legal right. So legal interest is all right, but no one would say equitable estate. So you can say legal estate, legal interest, but only equitable interest. Don't say equitable estate. The examiner or marker of your assignment will then throw your script out of the window. It's never heard of this term. So legal estate, legal interest, but only equitable interest. Now we'll come back to this meaning of legal estate and equitable interest a little bit later. Now, interest in land can also be used to denote or refer to those proprietary rights that one person enjoys in the land of another person. Now, ownership, of course, refers to the piece of land owned by you. But we may have interest in another person's land. Easement. Remember, in brief, the right to use your neighbor's land. So the land does not belong to you, but you have rights to use it in a certain rate. So you have an interest in that piece of land, even though that piece of land does not belong to you. Now, and well, this is not really important for your syllabus, but just to give you some idea, because I know many Hong Kong people are thinking of purchasing property in England. Now, before September 2004, freehold and leasehold were also main estate in England in land in England. So in England, they also have this freehold, indefinite duration, and leasehold, definite duration. There is an act called the Common Hold and Leasehold Reform Act 2002, and that act took effect on this day. It seems that there is one new estate, new interest in land called the Common Hold. Just to show, if you went to say an exhibition for British property, if you can ask the guy, well, about Common Hold, then the lawyer would look at you, this guy knows something. This essay is not actually applicable in Hong Kong, so you do not really require to know much about it. But the common hold, in short, refer to the common parts of a building on a registered freehold land. Now, of course, you have a piece of land, you cannot just lie there and sleep there without any housing on it. So, in many cases, on the freehold, we will erect multi-story building to house people. Now, at this stage, you would still believe that you are the owner of Unit 1A, you are the owner of Unit 1B. Let's forget it. Let me allow you to think this way. But what about the staircase? What about the common roof? They are called common parts of the building. Who owns it? Now, in England, under this concept, this interest of common hold, the common parts of the building are owned by a common hold association, which is equivalent to a company, called the Common Hold Association. And the members of that association are the unit holders of the building. So if you are owner of Flat 1A, you are also a member of this Common Hold Association. And the Common Hold Association is a company limited by guarantee. You have studied company law, you should know what is a company limited by guarantee, and is responsible for the management and maintenance of the common parts. So, in fact, it is similar to the incorporated owners in Hong Kong. So don't let this word misguide you, thinking that it is a new interest in land. It actually refers to the common parts of a multi-story building. Now, in Hong Kong, island of the Hong Kong Island, south of the Boundary Street in Kowloon, all land, with the exception of the land on which St. John's Cathedral stands, St. John Cathedral over Cotton Tree Road, was used to be owned by the British Crown before 1997, because they're ceded to England. Land including north of Boundary Street and south of Shenzhen River, and the outer islands, was leased to the British Crown until 30th of June 1997. That's why we have this problem, 97問題, come from here. Now, forget about what happened before the 1st of July, but since 1st of July 1997, except the land of which St. John's Cathedral stands, all land in Hong Kong SAR is now owned by the state of the PRC, People's Republic of China. And the ownership of land, therefore, is quite different concept of ownership of chattels. Now, if you own this iPhone, I hate this iPhone, I use a hammer, crack it, no problem, because you are the owner. But when you say you own a piece of land in Hong Kong, it is an entirely different concept, because the land actually owned by the state of the PRC. So land in Hong Kong is actually leased, you're renting by the government to landowners under quotation mark. You thought you are landowner. No, you are not landowner. for a term of years. All land in Hong Kong, except the land on which St. John Cathedral stands, are leasehold. Definite duration, definite estate. The landlord literally, legally, is only a tenant of the land. The owner is the state of PLC. You are just renting the land from the state of PLC. Of course, the Hong Kong government is the agent of the state of PLC to lease the land to you. So if Sun Hong Gay, Hong Gay, whatever, bid a piece of land by auction, they, the developers, do not purchase a piece of land. They just get a lease. And any lease, any land sold under quotation mark by auction after 1997, 1st of July, has a duration of 15 years only. Okay? So after 15 years, in theory, the lease expires, and you have to see what the state of PLC would decide to do. Whether they want to extend the lease without any payment or whatever. We don't know yet. So it is not accurate to use the word ownership to describe what the proprietary right a person has in land in Hong Kong. So this is another level of the answer for I own a piece of land in Yuen Long in the first slide or second slide. I do not own that piece of land. I only rent that piece of land from the state of PLC via Hong Kong government. Okay? So we do not say ownership of land. We use the term title, T-I-T-L-E, title, to express the proprietary rights one possesses in relation to the land. So when the land is sold, actually under quotation mark, the vendor must prove that he has good title to the relevant land, and he is able to pass a good title to the purchaser. If the title is not good, then the purchaser may end up paying a few $1 million and get nothing in return. Now, then how was the land, the lease, dealt with when Hong Kong became Hong Kong SAR on the 1st of July 1997? That has been discussed by the British and Chinese government and declared in the joint declarations. And the joint declaration were incorporated into the basic law. So Article 120 to 123 of the basic law said that all leases of land created before 1st of July 1997 will expire on 30th of June 2047. So if you are living in a house, in a flat of a building which the land of which was not sold after the 1st of July 1997, now your date to possession of that land or flat is numbered. On this day, 30th of June 2047, you have to give back the land to the Hong Kong government. Just like you now rent a flat for 2 years. After the 2 years, you give back that flat to the landlord under quotation marks. Because the lease you are enjoying expire on this day. Now, of course, if it is a new land sold after 1st of July 1997, then the lease is 15 years. So say, for example, if you purchase a property on which the lease was granted on 2000, then your lease will expire in 2050 years. So don't spend millions of dollars to purchase a flat, because you only get 15 years at most. And any lease expire on paper before this date, before the 30th of June 2047, but after the 1st of July 1997, under the original term of the lease, will be extended automatically to this deadline, to this date, at an annual rental of 3% of the rateable value as the date of extension. So that is the current arrangement. If you live on Hong Kong Island, for example, in most cases, your lease, the lease for the land your building rests would have been expired before June 30th, 2047. But the government said, okay, I will not ask you to return the land to me or ask you to make a payment for extension. I will automatically extend your lease. But it was only until 30th of June 2047. And in the meantime, you have to pay rent. What is the rent? Annual rent, 3% of the rateable value of your property. As long as you pay this annual rent to the government, you can stay on that land until this date. But what happened on the 1st of July 2047, we don't know. There's no indication whatsoever from the government of Hong Kong or from Beijing so far. Now, I'm not really discouraging you to purchase property, real property in Hong Kong, but that is the reality, okay? Yes? Yeah? It has already been deleted. Every list which was created before the 1st of July 1997 would expire on this particular date. Now, they are lists extend after this date, and that was the land sold after the 1st of July 1997. The Hong Kong government or the Beijing government so far only recognized freehold land on which St. John Cathedral stands. So in theory, after 30th of June 2007, go to St. John's Cathedral and stay there, build a camp, and live there. In theory, you can live there as long as the fathers there allow you to do so. Huh? The church, yes. The Anglican Church. So, land law in Hong Kong also developed from England. Two sets of rules subsist at the same time under the common law system, the legal rules and the equitable rules. And this dual system results in important consequential differences between legal estate and equitable interest. That is one of the reasons that land law is so complicated. Now, legal estate are regarded as real property in red. Okay? That's why we have to learn this term. And equitable interest as in person now against the person. And the scope of operation of equitable interest is, however, somewhat enlarged by this doctrine of notice, whereby the category of person against whom equitable interest can be enforced are extended. Now, in Persian law, that means you can only enforce the interest against the person who has the equitable interest. But this doctrine of notice extends scope for enforcement. And as equitable interest, court can also exercise equitable remedies, injunction, rescission, etc., so that they are not confined to damages. Now, it comes to the concept of legal and equitable interest, why they are important. First of all, we have to learn this concept called trust. And this concept of trust makes the concept of ownership of land completely a different story. Now, legal interest or estate, equitable interest, they come from different legal tradition. This is from common law, this is from equity. Now, those who study obligation law with me should remember the story about the development of equity. You know, in the old days, medieval age, the land which we now call Turkey was occupied by a Roman Empire called Byzantium. But the rise of the Islam religions also give rise to some powerful armies which overthrow the Catholic Empire and occupy Turkey. People, particularly Catholics, in Europe thought that that is not right. This is the land God gave to the Catholic Church. Islamic people, now I'm not against Islamic, I'm just talking about history, okay? Don't report it to the National Security Bureau. So, okay, we are going to get the land back for the Catholic country, kingdom. So, they are I'm not so sure I got this correctly spelled. 十字軍 crusade. A lot of European countries, including the British Empire, sent out soldiers, knights, to fight against the Islamic armies in Turkey. Now, in those days, only men can be owner of land. Just natural, right? Women could not. And all those soldiers usually belong to the noble class, would be owners of land. Now, when they went to Turkey to fight, what happened to the land belonging to them? Now, in most cases, the land would have been rented to tenants, you know, the farmers who farm the land, and they collect rent from them. Remember the doctrine, privity of contract? If the soldier's gone, the wife goes to the tenant, please give me rent. He said, sue me. And go to court. Court said, oh, I'm sorry, you don't have privity of contract. I can't entertain your claim. So, in those days, many soldiers make arrangement with their old uncles or some church members to say, well, I will transfer the ownership of my land to you, but I'm not giving you. Please collect the incomes for me and give it to my wife and children. Now, of course, in first or second years, those old uncles or church members would honor this promise. But once they learn the soldiers died in the battlefield, some of them would have second thought. Why don't I keep this land for myself? And again, the widows and children could not do anything. Because when they go to the court, same result. The court, oh, I'm sorry, there may be an agreement between your husband, deceased husband, and the old uncle. But you are not party to this contract. You have no right to enforce this contract. You're asking to, come back to earth from heaven or hell. So, those widows went to the king to make petition. Well, your common law court could not help us. And the king then think, oh, well, don't trouble me with all these things. Ask one of the most important official called Lord Chancellor. We still have this post nowadays in England. Please deal with all this petition. And this guy set up the church, the Chancery Court. And he said, well, we are not bound by the common law rules. We goes to the real agreement. The agreement is actually a trust. The soldier trusts this old uncle. The old uncle agreed. He will not take the land away, but will use the income to benefit the wife and children, before they die, before the soldier died. So, the Lord Chancery Court invented this one. Ownership of land is divided into two levels. One is called the legal level. That is the common law level. And we have an equitable level. This is the concept of trust. The legal level, the owner is a legal owner holding the legal estate. And this guy is only a trustee. He was someone trusted by the real owner. And the trustee is holding the legal estate of that land for the benefit of the beneficiaries. That is the wife and children. And they are the equitable owner. They hold the equitable interest of the land. So, this old uncle cannot take the land for himself. He has to hold this land, collect the rent from the tenant, and pass the income to the beneficiary. So to begin with, that is this concept developed by Chancery Court. Once this guy set up this concept of trust, now all properties, including real and personal property, the court will say there are two levels of ownership. One is legal ownership. The other is equitable ownership. And the legal ownership is held is held by the legal owner, and the equitable ownership is held by the equitable owners. And in most cases, the legal owner and the equitable owners are the same person. Say, for example, I purchased a house for myself. I would register the house in my name. Then I, of course, will be the legal owner. But at the same time, the house is for me. So I will be enjoying the right of and benefit of the house. So in that analysis, I am the legal owner as trustee holding the house for the benefit of myself being the equitable owners. This is the normal situation. But the legal owner and the equitable owner could be different persons. Say, for example, I have money. I don't want my wife to know I have this amount of money. I purchase a house, but register in the name of my good friend. Lest my wife will find out that I have this amount of money. Now, I have an agreement with this friend. I trust you. Now, don't betray me. You are holding this property as the legal owner, but for the benefit of me as equitable owner. So, if you rent this house out, you give me the rent. So, in this situation, my friend is the legal owner because the house is registered in his name. But he does not have the real enjoyment of this land. He is holding the land as trustee for the benefit of me as the equitable owner. So that is one reason that land law is difficult, because we have this split of ownership. Now, it's always possible for you to identify the legal owners, because later on we'll learn about that registration ordinance. All the legal ownership has to be registered. So you can find out, you have an address, you go to the land registry and you can find out who is the legal owners. But it is not always, and in many cases impossible, to find out who are the actual beneficial owners. Because in some cases, I want to hide my money. I would not put my name in the land registry. Otherwise, my wife can find it out. So the problem with many sale and purchase of land in Hong Kong is that when you are negotiating with the legal owner, you have to make sure that this guy has the authority of the beneficial owners to sell the property to you. Otherwise, you will be only purchasing the legal ownership without the beneficial ownership or equitable ownership. And in that case, later on we'll see a case, exactly the same situation. You may have to pay several $1 million, tens of millions of dollars, and get the legal ownership. And the law of trust goes one more step. All the beneficial owner holding 100% of the beneficial interest of the land can go to court and ask the court to compel the legal owner to transfer also the legal estate to them. So you may get your name appear as legal owner for a while, but after that a while, even your legal ownership will be gone. Now, that was the case Wong Chim Ying and Chen Kam Wei. Now we'll come to that case a little bit later. Now, so we have this trustee versus beneficiary. Trustee holds the legal estate. Beneficiary holds the equitable interest. Sometimes we call it beneficial, and sometimes we call it equitable. Both are interchangeably. Legal rights could only be enforced in common law courts, and of course that is traditionally, and equitable rights could only be enforced in court of chancery. But now, of course, these two traditions has combined. So you can go to court and have both enforcement done. And the effect of trust is to the separation of title, ownership of the land title, and real ownership. The property is owned by, first of all, a settler. Settler is the one, that is the soldier who set up this trust. And the settler set up the trust and vests the legal title on the trustee, whereas vests the beneficial title on the beneficiary. And the essence of trust is that trustee is holding the property not for himself, but for the benefits of the beneficiary. Now, the difficulty is that when the trustee transfers a property to a third party, it is sometimes hard to know whether this trustee does so, transfer the property in breach of the trust or for the benefit of the beneficiary. So that is another reason that land law is complicated. If you want to purchase a property, you have to make sure that you are purchasing both legal estate as well as equitable interest. If the trustee sells the property to you in breach of the trust, then you may end up only getting the legal estate. If a trustee transfers a property to a third party in breach of the trust, the third party may obtain the legal title only, and the property may be subject to the interest of the beneficiary. And at common law, the third party is only free from interest of the beneficiary if he is a bona fide purchaser, a real purchaser, genuine purchaser with value. He's paying the price for the property and without the notice of the existence of the trust. So he has no knowledge of the existence of the beneficial owners. If that's the case, you can purchase the property free from the beneficial interest. We'll come back to this concept a little bit later. So, a person may be the legal owner of a proprietary right in land. Of course, we do not say ownership, we call proprietary right. He can also be an equitable owner or holding the equitable proprietary right in land. In the case of ownership of land, normally the trustee holding the legal title and the beneficiary holding the beneficial title are the same person, normal circumstances, but they could be different persons. And at common law, a proprietary right in land is determined by the appearance or format. So we look at any documentary proof that you have the proprietary right in land, and that is your name being registered as the owner. So that is the legal right. So if a person is registered as an owner, this person holds the legal estate of the land. In equity, one looks behind the legal facade and find out who actually owns the interest of the land, and that is who actually holds the equitable interest of the land. And in case of land, the court generally only concern who makes the purchase price or mortgage installment. This is an important point that you have to remember. The court will just say, who paid? Who make the payment? If you make the payment, you acquire some equitable interest of the land. If you pay the mortgage installment, you acquire equitable interest in the land. So one can acquire equitable interest in land by contributing to the purchase price and or mortgage installment. But if this interest is not formally shown in the relevant document, that is to say it is not a legal estate, it can exist only in equity, and this becomes an equitable interest. And if you appear in the document, that would be a legal interest. due course, you'll see that certain proprietary right can only exist as equitable right, but there is no proprietary rights that can only exist as legal estate. And whether it is legal or equitable depends on how or under what format such right is created. And this is another reason that land law is difficult. Okay, maybe this is the good time for us to call it a date. I think you have lots of things to digest, after this first lecture. There's so many different concepts bomb into your mind. And that's why I say this first lecture is so important, because it set out all the important fundamental concepts of land law. Without understanding what I've said so far, you better go home. Don't need to stay for the lectures, because you won't understand.